Hi, I'm attorney Manny Sarah. I'm a partner here at the Rosen Law Firm. And in this video, we're going to talk about why officers don't always read you your Miranda rights when you're being investigated for DUI. So the question of why don't officers read you your Miranda rights when you're under arrest or being investigated for DUI? That question can be answered in various ways. But let's first talk about what your Miranda rights are. So if you've seen a movie, Cops, or a show, you've heard you have the right to remain silent. Anything you say can and will be used against you in court. That list of questioning and statements and your rights, those are your Miranda rights. It all starts with a guy named Ernesto Miranda. It's a case back from 1966. It's an Arizona case that was taken up by the U.S. Supreme Court. And the Miranda rights are established there, essentially saying that there can't be a comment to the jury on your Fifth Amendment right to remain silent. And your right to remain silent and have your rights read to you so you understand them are very important to your criminal case. And because you're innocent until proven guilty, you have a right against self-incrimination. So you have that right to remain silent. You have that right to have an attorney present during questioning. You have a right to be informed of these things prior to the police beginning what's called a custodial interrogation. So custodial interrogation is essentially you being in police custody. Now, you don't have to be behind a jail cell or in a cop car to be in the police custody. However, it has to be a scenario where one would feel that they're not free to leave, and it's a heightened scenario in that instance. And then secondarily, what's really important is that there has to be an interrogation. So that's not, the lights turned off and one light shining in your face and someone screaming at you and a guy smoking a cigarette in the back like you see in the movies. That's not really what it is. An interrogation can be something so simple as an officer asking you a question that's likely to elicit an incriminating response. That's really kind of the fine line legal definition that we get into in cross-examinations, and we ask a judge to make a determination as to whether that police action or question is such that it puts someone in custody, and then subsequently, whether there was an interrogation along with that, with the police activity. And so really, that covers really what Miranda rights are and when they kind of have to be read to you in a very broad concept. This can be, elaborated on in a 2-hour video. But for purposes of DUI, it's really tricky. And I strongly disagree with the law in the state of Florida as it pertains to what a custodial interrogation is for purposes of a DUI investigation. What the law states is that when you're pulled over for a traffic offense and then an officer maintains that you may be impaired, whether there's reasonable suspicion or probable cause to believe that you're operating a motor vehicle while your normal faculties are impaired, that officer will then ask you questions. Where are you coming from? Where are you going to? Have you had anything to drink tonight? And then secondary questions come along with that. After you've admitted to drinking, okay, I've had a few. What's a few? When was your last drink? What kind of drink was it? When was the last time you ate? That's not common everyday conversation. That's an interrogation in my opinion, okay? And it's my practice to file motions to suppress statements made in response to that police action. They violate your constitutional rights because the officer failed to read you your Miranda warnings prior to him really or her getting into their interrogation of you. Because when you're stopped in your vehicle for DUI, who here is reasonably going to feel like, okay, thanks officer, I'm going to get in my car and I'm going to drive away? If you do, make sure you hit the dislike button because that's ridiculous. All of us would kind of be a little bit timid or sheeple at that point and follow along with what the officer's saying because we don't want to get tased, shot, chased down, some crazy stuff we've seen happen. So we're going to listen and be polite and talk with the officer. Not that we agree with his suspicion or her suspicion that we're DUI, but we'll answer some questions. The officer will then go into asking you, hey, would you like to perform some voluntary field sobriety exercises? And you have a right to say no to those. But you don't have to be read your Miranda rights under the law at any point prior to all of this, unless there is that custodial interrogation, which I've mentioned before, that the purpose of asking you to participate in a DUI investigation, a lot of times courts are going to say, no, Miranda's not really read. You can still invoke your rights. So be very, very clear on that. You can still invoke your right to remain silent and your right to have a lawyer present, but officers oftentimes say, you're not entitled to a lawyer at this stage in the investigation. You need to either tell me you're going to participate or deny. and you're left standing on the side of the road there trying to make a decision that sometimes even lawyers get into appellate courts arguing over. So it's not fair to you. And so for me, in my practice, is to really challenge officers when they're going through their DUI investigations as to whether we cross the line from common everyday conversation to a formal interrogation and cross-examination even of you, given some of your answers. Now, after the DUI investigation has been completed, let's say you do the dance, meaning you do the field sobriety exercises, and the officer maintains that his suspicions have now been confirmed and he or she has probable cause to arrest you for the crime of DUI. Do your Miranda rights need to be read to you? The answer is no. So your Miranda rights don't have to be read to you. So there's common misconception. We have people talking to us all the time. They come into the office and the first thing they say is, we're just opening up the police reports. We're just getting into some of the nitty gritty, and a client or prospective client will say, Manny, they never even read me my rights. Can't we just make this go away? And unfortunately I say, listen, in a perfect world, yes, but them, meaning the officers, not reading you Miranda rights is not grounds for the whole case to be dismissed on its face. However, certainly if they fail to read you your Miranda rights and then they subsequently ask you questions that are likely to elicit an incriminating response, or you make some admissions on your case that make it go from winnable to, oh, this is going to be really hard to win. If we're able to cut those statements out, meaning suppress those statements in violation of your rights, your case gets a heck of a lot better. So there's a lot of times where I'll tell clients, look, it's not an end-all be-all, but it can certainly make your case a lot better. In sum, why doesn't an officer read me my Miranda rights during a DUI investigation or after a DUI arrest? I ask that question all the time in deposition. I'll ask the officers of DUI task force, hey, officer so-and-so, why didn't you read my client his Miranda rights? Oh, I didn't because I wasn't asking him any questions. Okay, but was he in custody? Yeah, okay. But would you maybe ask him a question here or there? Maybe, but it wasn't anything that was gonna, likely to elicit an incriminating response. And it leaves me scratching my head. So ultimately, why didn't you do it? I understand that you didn't do it, but why not? Because I didn't have to. Okay, so I know you don't have to, but can you explain to me why you didn't? No, I didn't do it because I didn't have to. And so juries hear that, and juries don't like that. Juries really don't like when an officer has an ability to inform you, to make you educated as a civilian of this country who has rights protected under the Constitution. They, being juries, don't like to hear that an officer failed to educate you on something that can protect you. And the reason why is just because they just didn't do it because they didn't have to, okay? Is that fair? No, it's not. And so I just want to make it very clear here that Ernesto Miranda, a defendant way back in Arizona, that the U.S. Supreme Court took his, case up and said, you know what, we find it that the civilians in this country, that citizens in this country are entitled to have a protection against self-incrimination. And when law enforcement is going to engage in a custodial interrogation, you need to be informed that you are now capable of hurting yourself, of hurting your freedoms, of hurting your family's freedoms. And you need to be informed of that through what's called Miranda rights.